Good.
Hello, good night. Welcome to Legalize this 7th day of September 2025. And tonight we have an esteemed panel to discuss and debate a very important topic for our community, the Age of Civil Legal Responsibility Amendment Bill 2025, which was placed before the Parliament of Grenada in July of this year. We have with us Mr. Dashan Ramdani, King's Counsel, Ms. Johanan Lafeuillee of Counsel, Ms. Layne Henry McQueen, a consultant, and moderating this debate and discussion tonight with me is Zita Barnwell, in the absence of Ms. Aisha McLean, who is the usual co-host, but who is not available tonight. But before we start off the discussion tonight, I want to recognize those who sponsor and assist us in having this program and carrying this program, namely Gel Professional Solutions Inc., Gem FM, carrying this station on FM radio out of Canada, and also Grenada Technical and Allied Workers Union, Zita.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
As I mentioned, the bill that we are discussing tonight has stirred up some passionate discussion in our community. Dashan Ramdani KC worked on the project and has a lot of knowledge of the bill that we are going to discuss tonight. Mistress Layne Henry McQueen was the project coordinator of the United Nations sponsored project that resulted in the particular bill, along with several others. And Johanan Lafeuillee, who I'll just call Johanan for short, is strongly opposed to the bill and has been advocating for changes, if not complete dumping of the bill. The format of the discussion tonight is that we'll have each of the three participants making a presentation we'll first have Casey, Dasha Ramdani, followed by Layne, then followed by Johanan. The Zita and myself will of course moderate. We'll ask questions in particular after the presentation of each of the presenters. Dasha Ramdani, King's Counsel, has close to 30 years experience in the legal profession. During this period, he has occupied various roles. As a private practitioner, he's admitted to practice in Guyana, Trinidad and Tobago, Grenada, and New York. Between 2013 and 2021, he served as a judge in the Eastern Caribbean through a number of intermittent appointments in St. Kitts and Nevis, in St. Lucia, Antigua, Anguilla, British Virgin Islands. And during that period, he delivered over 70 judgments. He has held the position of Acting Director of Public Prosecutions, Solicitor General, and the Attorney General of Grenada. He's the author of a widely consulted law text, Confession Evidence 2008, which draws on his criminal practice and related research. He has led legal teams on major consultancies, inclusive of teams of senior and junior legal consultants and legislative drafters. He was intimately involved in the process which led to the bill to reduce the age of civil responsibility, which is the subject matter of tonight's discussion. In 2021, Mr. Ramdani was promoted to the rank of Queen's Counsel, and of course, he's now referred to as King's Counsel. Good night, Mr. Ramdani, and the floor is yours.
Good night, Mr. Layne. Thank you for having me here. Miss Zita Barnwell, my colleague, Miss Lafeuillee, my colleague, Miss Henry McQueen, my colleague. Good night. Good night to all the listeners and the viewers on social media and on TV, and anyhow that you can hear this program. First, let me thank you very much for asking me to join and to share in what I believe to be a very, very important discussion. I have been for some months now seeing some snippets of the conversation. I live permanently in Grenada, but I have been journeying in and out. But I've been keeping an eye on the comments, and I found them very interesting. I think it's a very useful debate, very useful discussion. Many important points are coming from the attorneys, from civil society, in relation to this particular legislation. I hope that when we are finished here today, we will all be better off in terms of understanding the context of the legislation, the draft legislation that is being proposed, that we will have an insight in the kinds of problems, issues in societies that are hopefully being addressed. And if at the end of the day, we do not come to a consensus, that too would be a very good thing, because sometimes when we don't get to consensus, it raises further opportunities for discussions and debate. And so whilst I know there is vigorous opposition in relation to some aspects of this bill, I am hoping that at least the underlying issue would be better understood at the end of this program, and that at least an understanding will be there that we need to address these social concerns in our society. So here goes. I was lucky enough, fortunate enough to participate in the Spotlight initiative that was part of the efforts taken in Grenada together with the United Nations. It's a United Nations initiative together with the European Union, and the European Community, and they are working together with a number of Caribbean countries. And the idea is to ensure that all forms of violence, family violence, are removed and eliminated from society, that all forms of violence are eliminated against women and girls. Now, we know that violence does not only exist in a physical sense. There are many, many forms of inequalities in societies that create vulnerabilities in various categories of persons. And this particular project was aimed towards finding all of those vulnerabilities as they exist, inequalities in society where women and girls are facing unequal situations. And we have had to look at all of the legislation that exists in Grenada. Now, before I took on the project, my colleague in law, Richie Maitland, was the first consultant on this project. I took on from him, and I worked together with a team in Grenada and together with our very experienced drafter in the Ministry of Legal Affairs, Arya Redhead, who has done several masters in drafting. So we had a very formidable or experienced team. I would hope that you may agree with that. We may have gotten some parts not as correct as you want. But in examining, we started out by examining all of the international conventions, and we looked at the rights that were sought to be respected and protected. And we looked then at all of the laws of Grenada. In examining the laws, we were looking to see where did our laws fall short? Where were the gaps in our legislation that did not treat women in the same way as it treated men? We had situations like persons living in common law unions, and somebody dies in a common law union. There's no right of intestacy under the current laws of Grenada. And so that was one of the recommendations we made, that in certain circumstances, those persons would also be entitled to share in the estate of a deceased person if they could show that they lived in a common law union with that person. There were a number of other recommendations made, and we came up with just over 17 pieces of legislation, and there was a number of consultations taken. I appeared several times on national television. I also attended several consultations with McQueen. Henry McQueen was part of that process, and we met with civil society. We met with various groups in civil society. In fact, at the very end, I believe in May of 2022, when we were still in the throes of consultation, there was a symposium sensitization workshop of sorts held, and many persons were invited to this. It was held at one of the resorts in Grenada. I think UNICEF, together with the government of Grenada at that stage, also retained Miss Celie Burke, who is a well-known activist in this area of protecting women and girls and looking after rights of persons in Grenada. Miss Anandi Trotman Joseph was also part of that consultation exercise. Miss Henry McQueen was of course there. The Attorney General of Grenada then, Miss Dia Forrester, was part of that exercise as well. And so there were discussions, and we had prepared a paper. I had prepared something called a comparative legal gap analysis of laws in Grenada relevant to combating and ending violence against women and girls. I know my colleagues have seen it. Ms. Lafeuillee has seen that, and I know all of the lawyers have now looked at it carefully. We prepared position papers. Now, let me quickly say what they are. Our position papers really contain what we found to be the gaps in the laws of Grenada in terms of protecting women and girls, and we considered that there were going to be recommendations made to take care of these gaps, to make it a balanced society, to eliminate violence and vulnerabilities again in relation to women and girls in society. And those position papers were all discussed, workshops were held. The bar, most of the legislation that we drafted, in fact, all of the legislation we drafted at that stage was shared with the Bar Association. Now, when I say that, I will say this. This particular bill that now is before us for discussion, in the Spotlight Initiative project that we did, we saw the mischief, we saw the vulnerabilities, and we saw where health, women's sexual and reproductive health issues were not properly addressed in our society. That's the analysis compared to other countries around the world in relation to all of the conventions that we have signed on to. And these were the recommendations that were being made internationally. And so we made recommendations in relation to this bill. But at that stage, when I completed the project, this bill had not yet been drafted. I believe not so long after that, the government changed. And it is significant to see that I am still sitting here with you all, and I'm advocating essentially the government's position, which is a remarkable thing by itself. But when they took on, the current administration took on the recommendations and they looked at it, I understand from my colleague, Ms. Henry McQueen, that what happened, that there was still a revision of all of the recommendations. They relooked at these issues, and this act was the product of that discussion. This bill, rather, was the product of that discussion, those reviews, and so forth. And from speaking with my drafting colleague, Ms. Redhead, I know she did an extensive research into all of the countries in the Caribbean that deals with this particular area, and I will come to that shortly. So what were our recommendations? What did we see that we thought that public discussion, public awareness was necessary? And I say it that way, as again saying that this bill is necessary. I'll come to that shortly. But what it is that we saw that made us believe that even though you have the age of maturity, the age of civil responsibility, and the age of maturity is the same thing. The age of maturity, we say, and the age of civil responsibility is 18. And so anyone who is 18 above can make decisions for themselves. So what was really the issue behind this? And so we thought that when you look at the, give me a second. Yes. When we looked at the Grenada Age of Civil Responsibility Act, and that was an act passed in 2011, it's a relatively new piece of legislation. It assumes that a person becomes an adult at 18 years. And you know, many of our countries used to have 21 years as the age of maturity, age of majority, the age of maturity of civil responsibility. But that around the world has been coming down and has rested at 18 years. And what we found, and it was the experience of many other countries, we found that whilst you had the age of consent, and when I say consent, consent for minors was 16 years of age to engage in sexual relations. That was at 16. And yet that person was recognized to be of maturity at 18. These are our laws. And so we felt that having regard to what we have seen by way of sexuality, the growth of our children in the Caribbean, that it was necessary to consider implementing legislation that would allow children, because there's a considerable degree of stigma attached to when children begin minor. And I want to be very careful here, because as you notice, Mr. Layne, apart from yourself, I am the only gentleman sitting here. And we are speaking of women's and girls' rights and reproductive rights and so on. Mm-hmm. So I hope I am very careful and that I address it in the most sensitive manner. But we are talking about a sensitive topic. Hence, I will be saying certain things. So we have recognized in Grenada and the entire Eastern Caribbean, in fact, even the countries like Guyana, where I sit, and Trinidad and Jamaica, we have issues with children and sexual relations. We have these issues occurring. Our sizes, there are many matters there which take up the majority of the list. And so there are studies being done around the Caribbean. And one of the things they found was that when people engage in these activities, issues can arise, medical issues. Somebody engaged in sexual relation, several things can immediately happen. There's the danger of STDs, and there's the obvious one, which we have seen in the entire Caribbean, which is pregnancies. And many minors, not many, but perhaps a significant number of minors, when they are in these places where they have engaged in sexual activity, that what happens is that the question arises, well, are there any health issues that will arise? Now, I only need to say that for you to understand that we can hardly know, apart from obvious cases of injury, whether health issues will arise when someone engages in a sexual act. And so the medical component or the medical element of life becomes very relevant when you consider there's a child sitting somewhere, 17 years of age, a minor, not at the age of civil responsibility yet. And I'm putting it at 17 now because I know we have on this bill much lower ages, and I'll come to that. And that person is sitting there and is obviously anxious. They're not at the age where that they can get married, and they are at the age where they can consent, and they have consented, and they are in that place. And then they begin to worry. And they begin to worry, and that worry, because of the way our society interacts. I am a parent myself. I'm a parent of a daughter, of two daughters. One is just about to be 13. And so I understand, I hope, I understand the ramifications of the discussions we're having. And so that child is sitting there, and that child has several things to think about. One of them is to go to the parent and talk to the parent. Remember, this child would have engaged in this act without the parent knowing. That would have been the starting position. Mostly, it's hardly likely that they will talk to their parent on the age and then get their consent. They wouldn't. And so the next question is, the child is sitting there, and imagine for a moment that 17-year-old has perhaps, and I say this again, this is a very sensitive topic, perhaps contracted a sexual transmitted disease. And that child is sitting there, and many months is going to pass because she is afraid of speaking to someone. She's afraid of talking. Now, this bill is not going to wipe away the fear if it becomes law. I understand the bill is not going to wipe away the fear, but the bill, hopefully, this discussion, desensitization seminars will change a little bit of how society views themselves, and there'll be support groups and so forth. But is it time for us to address that need in society where someone is sitting there and some STD is fermenting in that person's body? Is it time that that person knows if they go to the hospital, the doctor is going to call my mother, the doctor is going to call my father, and they delay and they delay and they delay, and the mischief or the damage, the harm. And what I am saying here is what most of the world has agonized over. Those countries that have passed and reduced the age of civil responsibility, they have agonized over this. Jamaica has passed a law in 1979. Let me repeat that. Jamaica passed a law in 1979 reducing the age to 16. So you don't have to be 18 in Jamaica to go to a doctor, and they don't narrow it or restrict it to sexual and reproductive health. The Jamaica provision relates to all forms of treatment, where a 16-year-old can walk into a doctor's office, and that 16-year-old doesn't have to show that she is of sufficient maturity or whatnot. She goes in there, and once the age is established, that person can have medical treatment without the need of consent from a parent or guardian. That is in 1979, Mr. Layne. Yes, Ms. Barnwell. That's in 1979. Now, I've looked at another report coming out of United Nations, and I'm seeing that across the board generally, except for a few Caribbean countries, and Grenada is one of those few, most of our Caribbean countries have legislated and brought the age of civil responsibility where you can go and seek medical treatment without the consent required of your parent or guardian down to the age of 16. In fact, Guyana recently, by administrative measures, and they've brought in the GILIC test. The GILIC test is that test which allows the medical practitioner when faced with a child, to ask that, to put that child through an inquiry. So we have a child walking in, the child under the Gillick test, any age of a child generally, and the child comes in. And let me tell you very quickly, I know I have a timeline, Mr. Layne, but I will take a couple moments more. In the
Yes,
Gillick,
you all.
the, the mother of 5 daughters challenged a UK Department of Health circular that allowed doctors to provide contraceptive advice and treatment to girls under 16 without parental consent. And the question was whether a doctor could lawfully provide medical treatment, specifically contraceptions, to girl under 16 without parental consent if the girl showed sufficient understanding. And this matter went to the House of Lords, one of the highest courts in the UK. And it says here that a minor child under 16 may consent to treatment if they possess sufficient understanding and intelligence to fully understand what is being proposed. Yes. And the doctor cannot persuade her to inform her parents, and that she's likely to go ahead and still do the act, notwithstanding you're telling her or advising her not to, and that her physical or mental health is at risk without treatment, and that treatment is in her best interest. Now, I have seen some of the criticisms in relation to this, but this is now law in the UK. Guyana has recently put it in place where administratively they are now, because it's the law in the UK, it has gotten into a common law concept and it has evolved with the law. So most countries under the common law can to receive these principles. And there's an argument that Grenada also has already received these principles. I suppose a court case may have to come to say, well, we have received the law that has evolved in the UK. But Guyana has gotten to that point. And Guyana says this very same thing. So any child goes into a doctor's office and goes through this examination. Now, you don't expect the doctor to sit there alone. You'd expect that the doctor will have a nurse, and perhaps a welfare officer would be there, and perhaps child protection agency would be involved at some stage. I've seen the criticism, and they're very good criticisms. Ms. Lafeuillee criticisms, I've seen some of them are spot on in relation to how we need to approach some aspects of this. But let me tidy up what I was saying in relation to the 16 years of age issue. Grenada, that subsection which says 16 and above, a minor 16 and above can consent to medical treatment. We are not unique in that regard. Since 1979, one of our Caribbean sisters country have gotten to that stage, and many others have gotten to that stage. So Grenada and those societies are similar to ours. And so if they're similar to ours, they have recognized a societal problem. They have recognized a need, and that we need to have that protection. Sexual and reproductive health, it's not only sexual and reproductive health, it's a right, it's a fundamental human right that is ingrained with all of the other fundamental rights in our Constitution. Everyone is entitled to fundamental human rights. And these treaties and international best practices have recognized that. So the other subsection of the legislation is the one which has also, in fact, generated more concern. It has generated more concern. And it is saying, listen, watch. Even if for a moment you could justify reducing that age of civil responsibility for sexual and reproductive health reasons to 16 and above, a minor, what business do you have putting it to 12 up to 15? And first of all, I will say this. When I examined the legislation that is drafted, the bill, as I said, we left the recommendations in, and the legislation is now, the bill is now drafted. What I see is that as drafted, this particular bill does not give any doctor any right to do anything to any 12-year-old, treat or otherwise advise, treat to 12 or 15-year-old in our country at all. It doesn't do that. Now, I believe all of the lawyers understand that. And the criticism is, well, we are giving the power to a minister to make an order. We are putting it in the hands of a politician. Again, I would ask my colleagues to read the language of the bill that is written. And what you see is this. Well, first of all, let me go to the end and then come back at the beginning. The end of any policy order that a minister drafts will have to get affirmative resolution from Parliament. Now, what does that mean? Affirmative resolution from Parliament means in Grenada that both houses of Parliament must debate and vote on this order. So this is not a negative resolution where minister can sit in chambers in her office, write out a policy, stamp it and call it an order, and it becomes the law until Parliament knocks it down by a negative resolution. A negative resolution is where Parliament says, no, you can't do that. A affirmative resolution requires Parliament to say yes before it becomes law. And like every other bill, like how we have this bill was, I think, this is useful. This conversation is critical to Grenada. It is a very critical conversation. And the Attorney General, they withdrew this bill from Parliament to engage in this exercise. That was a very positive thing to do. Maybe it should have come before, but here we are engaged in this positive exercise. This bill, that section that speaks of an order, sets up by the express language. It tells the minister, and it will tell Parliament too, that the minister can't simply make an order for 13-year-old and 14-year-old to get advice on unwanted pregnancies that may harm you in the long run if you're not treated for something that is happening to your body, right? So, for instance, let us assume that this child, that we see that we have a problem in our community relating to 14 and 15-year-olds getting pregnant. Let's say that. I've spoken to some of the doctors at the hospital, and I know that we may not have the biggest problem, but we have concerns. Let me put it that way. We have concerns in our society with young girls getting pregnant. So a child gets pregnant and she's at that stage. Is it the time in Grenada when a minister may want to consider a policy that deals with that age group? Is it the time? And what this bill is really saying is, let's have that conversation, but we are creating a broad platform. We are creating a broad mechanism here. This is not the law. If it is passed in this manner, every order the minister makes may be stopped by this very same, these express agitation, this express concern by the bar and other members of society. Exactly what has happened here when the minister attempts to draft an order, and if society recognizes, well, look, your order doesn't really satisfy the Gillick test properly, because you could put as a condition in the order the Gillick test must be there. You could also put in the order that the doctor must be accompanied by a social worker, by a child protection officer when the doctor is sitting there. So it's not a doctor, one single lady doctor, one single man doctor sitting there with a child telling a child something. We can put that in the order that you must have a child protection officer present. You must have certain parameters set out in the order so that when the child turns up, there is an entire system in place, not a solitary medical professional, but an entire system in place which is designed to meet that child and to solve that social issue that we are recognizing in society. And that doctor should be required to put reports. Mandatory reporting can be a condition of the order. So we implement mandatory reporting, and we can set up a parliamentary subcommittee that will review these reports, analyze the concerns, because Ms. Layne, Ms. Barnwell, Ms. Lafeuillee, Ms. McQueen, Henry McQueen, the medical treatment by these doctors, the medical advice and treatment by these doctors will not end. The issue doesn't end there. These children will be going back into their homes. The concerns and all of the other consequences are going to flow. When such a policy paper becomes legislation and an order is presented to Parliament, we would expect that all of the stakeholders are ready to discuss all of the needs that exist in society, so that when an order is eventually going to be approved by our Grenadian Parliament, that all of these issues are thought out, because even that home will need some attention. Where that child comes from, there will need to be safety nets put in place in relation to that home. Yes, let's assume it's not a situation where somebody in the home is perhaps the errant person or the bad behaved person. But regardless of whether that is so or not, that child is coming from a home. And whatever medical treatment we are going to put in place, we also must have safety nets in place. And this order, whichever order that comes out from this, must address all these issues. So, Ms. Lafeuillee, conversation is a significant conversation, but we cannot go into the desert and say, well, we are not ready to address it, so leave it alone. I am thinking that as a start, we must agree that following our Caribbean sisters and brothers, following the experience of Jamaica from 1979, following other countries, including Guyana, putting it in place for any age of a child, that we must recognize, at least for 16, there is a need that persons who can consent to sexual intercourse should also be in a position to consent to medical treatment in relation to their personal self. That is part of the fundamental human right. Once we get to that agreement, we must then recognize that the other provision in the bill is simply a provision which opens the door to discussion. Nothing in that order can become law unless it goes to Parliament and unless it's debated, unless both houses sit and by majority rule on it. So what we have in this bill, Mr. Layne, what we have in this bill is the opening of a door of enlightenment, that we are recognizing the vulnerabilities of girls in Grenada. We are prepared to address it. We have a mechanism that is designed to cater for every possible eventuality of human thinking. When you get to that order, all of these issues that we are discussing now and before and after will be brought into that order. And I hope that our governments remain concerned, and this discussion is clearly signaling that, concerned to get it right, to get it right. And I'm sure the opposers today will guide me, guide us all where we have work yet to do.
Mhm.
And so I propose that the conversation continue. Thank you very much.
Thank you very much, Casey. Uh, we have a section for questions, but I think Zita, we probably don't need to ask any question at this time. Maybe we should just let the discussion flow. So with that, Zita, if you could invite
Okay.
Elaine to come out.
Yes, thank you, and good night, everyone. Thank you so much, Casey, for that background, well articulated. And I will now introduce Ms. Elaine Henry McQueen. Elaine Henry McQueen is a goal-oriented gender equality and program management professional. For over 30 years, she mobilized and collaborated with civil society, government, and the international community to develop and manage policies, programs, and projects on women's rights and gender mainstreaming with emphasis on ending violence against women. She held leadership roles in Grenada, Union of Teachers, Grenada National Organization of Women, Caribbean Women's Association, and the Cedars Home for Abused Women and their Children. She was the Senior Program Officer for the Division of Gender and Family Affairs in the Ministry of Social Development. Elaine last worked as Program Coordinator for Grenada Spotlight Initiative to End Violence Against Women and Girls, a United Nations joint program with UNDP, UNICEF, PAHO, and UN Women. She currently provides consultancy and training services on gender mainstreaming, women's empowerment, social justice, education, organizational development, and project management. She was recently appointed as the principal expert from Grenada to the Committee of Experts of the Follow-up Mechanism on the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women. Welcome, Layne.
Thank you very much, Ms. Barnwell, and thank you, Mr. Layne, for inviting me. Good evening, Ms. Lafeuillee, and to all our viewers and listeners. Mr. Ramdani, it's a pleasure to be working along with you on this again. I want to set a further background to this bill and to speak a bit about the policy considerations that would have impacted on the decision to go forward with this bill. Now, there are some overarching policy considerations that had to be taken into account. One of them emerged from the Convention on the Rights of the Child, and that is the best interest of the child. That's a policy consideration. It's a principle that had to be looked at, the best interest of the child. The convention tells us that parents, government, institutions, everyone who interact with children are expected to set policy, to provide services, advice, etc., that are in the best interest of the child, which means that the adults who are making decisions in relation to the child have to make decisions guided by what should be in the best interest of the child, not decisions that are based on their own whims and fancies or their own interests, personal interests as adults. It's not about power over children, but it is about the best interest of the child. Another overarching policy consideration or principle had to do with the right of the child to age-appropriate sexual and reproductive health education and services. Age-appropriate sexual and reproductive health education and services, right? It is a right that every child has. Every human being is a sexual being, and therefore every one of us has the right to sexual and reproductive health care information and so on, so that we can make decisions in our best interest. The right of the child has to do with age-appropriate care, age-appropriate information, age-appropriate services, and so that had to be taken into account. The third thing that had to be taken into account was the evolving capacities of the child. Evolving capacities recognize that children are in stages towards maturity from the time they are born, right? They are progressing through childhood, becoming more and more mature each day on the way towards adulthood. And then, even as adults, of course, when we have to speak about adults, we still grow and continue. We have continuous learning.
Elaine, not to interrupt, but I think the audio, I thought we had it right before we started, but it's a little bit off.
Is that better? Hello?
Just continue and we'll see.
Okay. That's unfortunate.
Just continue.
Okay. Let me make sure, let me switch camera to the, sorry, not camera, but audio to the computer. I was using the headset. Right. Is that better now?
Far better.
All right. Fantastic. Right. So I was giving some policy considerations, and one is the best interest of the child. The other is the rights of the child to age-appropriate sexual and reproductive health education and services. The third is the evolving capacities of the child. And the fourth is protection of children from abuse by increasing the spaces and opportunities for information and support from professionals. So in terms of the evolving capacities of the child. What I was saying is that children are going through childhood, growing and learning and developing, maturing. They're on their way to adulthood. And as a child grows, as a child becomes more and more mature, she or he becomes more capable of autonomy. And that is an expected part of the process of maturing. As a matter of fact, it's common sense. At homes, we know that there are things that a 7-year-old child will not be permitted to do, such as light fire unattended, but a 13 or 14-year-old will be able to do that, perhaps cook an entire meal unattended. We know that because children, as they mature, become more and more responsible, can make decisions, and need to exercise their voice and their agency and learn who they are, becoming mature. And the fourth, as I mentioned, is protection of children from abuse. And one of the ways to do that is by increasing the spaces where they can report said abuse, if such abuse happens, opening the spaces and the opportunities where they can get information, they can learn about it, they can get support, but from professionals. Now, children will speak and learn about a lot of things, including sexual and reproductive health and rights. But if we close the door from professionals, it means that they will get that from non-professionals. They would go to the internet. We don't know who is there. They might be groomed for other things, and we don't know who is grooming them and who they're contacting. It might be on the block. It might be from their peers. It might be from abusers, and so on. When the door is opened for children to get the official guidance and support and care from professionals, and the space is created, a safe space is created for them, we get the confidence that the children then can exercise those rights and use those services as needed. Now, the bill under discussion, as Mr. Ramdani said, speaks about giving that access immediately to children who are 16 and 17 years old. And it also recognizes that there may be the need, it says may be the need, for an order to be made. And as Mr. Ramdani said, the discussions around the regulations, the parameters that define that order has to be developed very carefully, debated, and approved before it can go into effect. Now, I also want to share with us some realities that we need to be mindful of. Children have been experiencing sexual activity, including sexual intercourse, in Grenada. In the current situation, it has been traditional and it is there, right?
Any statistics on that?
Yes. The Women's Health and Life Experience study conducted in 2018 lets us know that 1/5, 20.5% of women had experienced sexual abuse as a child. 1 in every 5 women in Grenada experienced sexual abuse as a child. It also stated that 10% reported that their age at first sex was less than 15 years old. 1 in every 10 women in Grenada reported that the first time they had sexual intercourse they were less than 15 years old, right? Now, the study also gave a qualitative component, and it says that one example was of a woman who reported that she was 6 years old at the time she was first abused by her uncle. Her mother had traveled. Her uncle was abusing her. It he continued to do that until she was about 11 years old. And that's one example. There are several others in that study. And those of us who've worked along with children know of many more. Survivors of child sexual abuse also reported that perpetrators by and large were relatives, in-laws, neighbors, and friends of the family. And it also showed that underreporting is quite high. And can we be surprised? Now, we also saw a study from, well, a dashboard from UNICEF, and it showed that there is a measure, that there is a way of measuring the burden of disease on a person. It's called Years Lived with a Disability, YLD. And for Grenada, it shows that anxiety disorders is the leading cause of YLD for girls 10 to 14 years old. Why should a girl 10 to 14 have anxiety? For boys, it was the third highest. There were two other things ranking above that, but boys also experience anxiety disorders, right? For those boys and girls between 15 to 19 years old, anxiety disorders and depressive disorders was numbers 2 and 3 for boys. For girls, it was numbers 2 and 1. So the first was depressive disorders for girls 15 to 19 years old.
And those are considered proxies for sexual activity, sexual abuse. In other words, when somebody
proxies, but what it shows is that the level of anxiety and emotional distress is high. Now, when you couple that with knowing that 1 in 5 women has been abused as a child, one can draw some
conclusions,
correlations, but it does not say one is a cause of the other.
Okay. Okay, so now, if you could just wind up, Eden, because we...
Yes, I will. Sexual offenses have also been reported to the police. And in 2017, there were 335 cases. And interestingly, the numbers went up 2018 to 19 to over 400, and it went back down to just over 300 again up to 2022, which are the stats I have. Among them, sexual intercourse with a person under 13, sexual intercourse with a person between 13 and 16, and incest also rank high. The Assizes list in Grenada shows a very high prevalence of sexual crimes having to go to the High Court. Now, all of these point to some serious gaps, and so I will end in a few minutes, but just by saying here that the intended benefit of this bill is to provide access to essential health services, to address teenage pregnancy, to reduce HIV and STIs, that is sexually transmitted infections, to align with international human rights standards. It also allows Grenada to protect girls and boys, because boys can also report. Whilst this bill came up as a result of violence against women and girls, it's not saying that it's only girls who are provided with these services, but boys as well. And that is especially sexual abuse. It also promotes equality and reduces stigma. And the aim is to strengthen public health outcomes. Now, there is one additional benefit. When a child is able to report abuse, to report issues related to sexual and reproductive health, and discuss it in a professional environment, we hope to see that discomfort with pap smears and prostate tests disappear over time because children will start to be able to trust to the health system. And even as they grow into adulthood, that problem should be reduced. We hope over time to see that there is less uneasiness in talking with partners, including married partners, about sexual health and sexual activity.
Okay.
And we hope to see the fear of talking with children reduced. Remember that absence of services does not mean absence of the need for
Right, yeah.
services, right? And
Okay.
the need is
Right.
there. The
Mhm.
aim is to provide access. I end here. Thank you very much.
Okay, thank you. We just we have a clip now from the DPP, which also addresses the need, and it aligns with what you were saying there, Elaine. So if we could just get that clip, please, Bentley.
Serious social crisis in Grenada. Director of Public Prosecution Christopher Nelson believes that there is a serious social crisis in Grenada that requires the kind of intervention and measures that the Age of Civil Legal Responsibility Amendment Bill is seeking to adopt. As a high-ranking member of the judicial system, Nelson says the kind of challenges that exist currently questions the moral standard of parents especially and their obligations. Nelson says oftentimes mothers do not play their role responsibly.
Cooperation from parents and guardians of minors at times is a serious challenge. Only 2 weeks ago, we had a trial in the High Court involving a minor who was abused by his stepfather. The mother of that minor was openly hostile to the prosecution. The father of the child, whom the child did not live with, stepped in to assist us in moving the case forward. Left up to that mother, there would be no case. The case would be derailed. Instead of standing with her blood, her child, her daughter, she was standing with a man in the face of the court.
The DPP says that if children 16 years and over can consent to sexual intercourse and acts of indecency, then why can they seek medical attention without the consent of their parents?
So there is the need to give some public functionary, and in this case the Attorney General, who in all cases involve children assumes responsibility. For instance, in relation to adoption, it's the Attorney General that steps in. There are certainly cases where 12-year-olds and cases involving 12-year-olds have been handicapped by the lack of cooperation. And this is nothing new.
He says there is nothing to be alarmed about.
So we see nothing to be alarmed about in such situations. As I said, from our experiences, there are many situations where, left up to the parents or the guardians, children will suffer. And if the objective of this act is to achieve that, if sufficient safeguards are in place to support that, we have no objections whatsoever to the measure.
He is therefore calling on Grenadians to look at the bigger picture. A pervert, he says, may see this bill as an opportunity to commit a crime. However, many others can be saved.
But as I said, the devil may be in the details. And once it can be configured to deal with this situation that you have raised, as was pointed out, that should be considered. It should not be struck down because of one possibility. Let us look at the other possibilities, the other benefits.
Grenada, he noted, has a social problem that has heightened in recent years. With the introduction of the Age of Civil Responsibility Amendment Bill, Grenadians are voicing their concerns on how and if the bill will affect their children. Some even took to the Parliament building bearing placards in protest. For MTV News, Rachel Bain. Director
Yes. So we have the position regarding the need for and support for the bill, and we will ask Johanan to put the other side.
Certainly.
Zita will introduce her. 1 minute, please, Johanan.
Yes, allow me, please, Miss Lafeuillee. So, at this time, I will introduce Joanna Lafeuillee. She's a dedicated Caribbean attorney at law based in Grenada. She has over a decade of legal experience and is deeply committed to upholding justice and advancing sound public policy rooted in our shared Caribbean values, constitutional principles, and love. Joanna has been at the forefront of advocacy and education surrounding proper jurisprudence and the societal implications of legislative reform. She advocates that public policy must take into consideration our shared social values, our faith, family, and freedoms, and the impact on our vulnerable economies. Joanna has emerged as a leading voice raising public awareness on the controversial Age of Civil Legal Responsibility Amendment Bill 2025, expressing concern about its potential to override parental consent, weaken family structures, and expose children to undue risk. Informing and Informing and advocating her views, Joanna draws from her understanding of national law, international conventions, cultural norms and values, and from spiritual conviction. She champions the call for transparency, consultation, and dignity in the treatment of children, parents, and families in Grenada and across the region. Welcome, Joanna.
Thank you. And thank you to you, Ewart, for the invitation. I want to thank my colleagues at the table as well for taking the time to lay out in simple language the policy considerations behind the bill. I want to first state that I am not speaking from any political motivation. Though in the recent days, of course, I engage social activism, even some acting, just to raise awareness, because from the time that I saw this bill, as my colleagues would attest, it really jolted something in me. From the day that I saw this bill to now, my heart is beating a little differently, and for good reason. So my underlying premise that I want to be transparent about is that my position is that the bill in its current form is overbroad. It disregards parental authority. It disregards the rights of the child under international human rights instruments. It is philosophically dangerous, legally flawed, and obviously socially disconnected from Grenadian norms and family life, given the unrest in the social space over this bill. So we've heard about the issue, the problem, and there was a recent a recent video on No Grenada. And from my recollection, and I stand to be corrected, the statistics show that in Grenada, there's a significant jump in sexual activity between age 15 and 17, basically the form 4s and 5s. So we know where the issue lies. We know who the target group should be. Before I go forward, I want to read a quote by a man that is very important to the abolition of slavery. In fact, he had a bigger issue than Grenada has today. Slavery at the time underpinned the UK economy. And this man, William Wilberforce, a young 20-something-year-old politician, bared efforts to effectively get rid of that scourge from the society. So we have a social problem. We have a social scourge that we need to deal with. Listen to what he says. The most effectual way of preventing greater crimes is by punishing the smaller and by endeavoring to repress that general spirit of licentiousness, which is the parent of every vice. I know that by regulating the external conduct, we do not at first change the hearts of men, but even they are ultimately to be wrought upon by these means. And we should at least, so far, remove the obtrusiveness of the temptation, that it may not provoke the appetite, which might otherwise be dormant and inactive. And I'm reading this quote because it is important. We've seen from the statistics on that now show that there's a jump in sexual activity between Form 4s and 5s around that age group. And littered in the discussion that happened before I spoke, certain issues were aligned, like incest, trusted family members, violating young girls, etc. And to that point. So we know the issue. I want to also be further transparent to indicate to the listening audience and to my the guests on the show who may not be aware that this Trojan horse we're dealing with did not just enter our stables. In as recent as November of 2023, the Samoa Agreement was signed by a Mr. Raphael Joseph, who is the resident ambassador in the Kingdom of Belgium, acting on behalf of the state of Grenada. The agreement tied us to some very demoralizing things, and I'm going to outline what those things are here today. And like an altar on which life and innocence of Grenadian children could potentially be altered, Grenada agreed to sweep our social norms and frameworks that have served us for many years for 30 pieces of silver, so to speak. The European Union will allocate substantial amounts of funds amounting to billions of euros to support all activities and projects pertaining to the agreement. Let us look at Article 8.7 of this EU OSCPS Samoa Agreement. It legally binds parties to implementing what is called comprehensive sexuality education in UNESCO's International Technical Guidance on Sexuality, which is also based on the WHO standards for sexuality education in Europe. Let's look at this further. We talked about age-appropriate education that was mentioned by Miss Elaine Henry McQueen. Let us look at this for what it is. Let us eyeball this, Grenadians. Same-sex and transgender can be parent. Comprehensive education to children. Supporting homosexuality and transgenderism, 15 to 18-year-olds. Describing pleasure, kissing, caressing, sexual contacts as showing love, 5 to 8 and 9 to 12-year-olds. Masturbation being natural and unharmful. Children should do it privately from as young as 9 years old. Accept and respect same-sex relationships, 4 to 6 years old. Sexual intercourse, different methods of contraception, 6 to 9. The right to explore nakedness, the body and gender identity, 0 to 4 years old. Sexual feelings, excitement as human feelings, use sex language, 4 to 6 years old. First sex encounter, decision to have sex, dating, masturbation, orgasm, 9, as young as 9. We have signed on to this. Early childhood masturbation, 0 to 4, 4 to 6, 6 to 9-year-old, enjoy touching one's own body. So let us talk appropriate sexual education. My point is, do not be deceived. This appropriate education is encapsulated in a pill that is EU-led, EU-funded, and driven by, as I said, I call it outside forces. Now, very recently, Grenada celebrated, and international press ran, that Grenada's opposition and government joined forces to drop the oath of allegiance to King Charles, effectively removing him as head of state. The change removed the words His Majesty King Charles, etc., from the Pledge of Allegiance and replaced it with Grenada. And what I am saying before I continue, in the same manner, we ought not to bow to EU values. The age-appropriate sexual education and this that was espoused by our former speaker is clear. It does not align to Grenada values. So permit me to, having touched on where this thing is coming from, I also want to note that the Trojan horse doesn't just end there. The term sexual and reproductive health is a Trojan horse. It is used deceptively to bring corruptions into our countries that does not align with our social values, our norms, our religious ideals, us as a people, our fingerprint as a Grenadian people. So let's look at Article 36.2 of the same Samoa Agreement, and 48.7, legalizing contraceptive for adolescents, legalize abortion, legalize prostitution, legalize same-sex marriage, legalize LGBTQI and sexual orientation, gender identity in school curricula, legalize LGBTQ and LGBT agenda and name change, legalize access to hormone drugs, gender reassignment, surgeries, states cover cost, no right to conscientious objection from medical practitioners, legalize fertility services for transgender persons, legalize pregnancy-related services for transgender men, and the list continues. So now that we are very transparent on what we have signed on to and what these sexual and reproductive health services does include, I must say that we as a people must not feel bad from being gaslit. Why is it gaslit? Because the term reproductive and health services may sound like a good thing. It's sugar-coated on the top, but beneath it, in the use of the words of the TPP, which I have become fond of, the devil, my Grenadians, is in the detail. And so, I want to also ask, because the issues were being highlighted, so we all are clear on the issues that brought this bill to the table. Where is the 10-year-old in all of this? Where is the protection for the 8-year-old and the 3-year-old in this bill that is so delicious and so good for our children and our society? Do you see the inherently flawed policy backing these emotional exceptions that are put forward? Why? Because the 3-year-old that is being abused is nowhere in this bill. The 8-year-old that is being abused is nowhere in this bill. So where does the bill leave us? Does it really leave the girls, the most vulnerable of the girls, ages 0 to potentially 12? Does it lead them any step further to betterment to be protected? And my people, I want to say this. In the making of jurisprudence, and the lawyers at the table could attest to this, my colleagues could attest to this. Laws are made for the society, not the other way around, not to change the society, not to effect foreign values for money on the society. And Thomas Aquinas, because he put it so well, I'm going to borrow his words, respected philosopher and theologian, he says, simply put, law is an ordinance of reason for the common good, made by him who has care of the community, made by him who has care for the community. And I am saying our Grenadian values, norms, mores are to be counted for something in the whole grand mix of this. I am now going to look into the bill's loopholes. Starting with the fact that the explanatory notes vests quote sole legal capacity in minors age 16 and older. I take the Good King's Council's point that it is the fact that, and as the DPP said, a girl age 16 can consent to acts of indecency, so to speak. And so I'm going to deal with the 16 and older first. And what I have to say about that is even the 16-year-old, ask the medical doctors. There are medical doctors who interface with 16-year-olds coming to the ward to deliver. And I understand from based on what they have said, increasingly they're faced with complications because their organs are not fully developed. I'm going to also touch lightly on Gillick. I am trying to be as brief as possible because of the time constraints. Gillick in particular does not reduce the age of consent. Gillick deals specifically with tests prescribed for medical practitioners. But in this bill, where the age 16 and older is concerned, is a blanket. I understand that that may be the case in Jamaica, but we are not Jamaica. We are Grenada. And there are many parents who have written to me to say, I have a 17-year-old even, and I will never go to the doctor without him or her, or she, because of the medical background of the family and certain allergies that the child, and all of that, all of those considerations. The last speaker mentioned that the child will be safer if they come into a professional environment, perhaps with a child welfare authority officer, with a medical doctor, an aide, or whatever. And I'm saying, given the current state of Grenada's medical situation and health situation, let's not call it a crisis, we know so bad, but we know the situation. The bill effectively proposes to make the state a surrogate state. And so I have my criticisms that need to be ventilated here. The bill in and of itself lacks the international obligation to adopt such an amendment. We're talking proper jurisprudence, right? As a general matter, the legislative proposal is at odds with the duties of the states under the Conventions of the Right of the Child. The cornerstone international treaty on the rights and protection of children is explicit in recognizing that children, defining terms as generally anyone under 18, requires social protection on account of the lack of maturity. Quote, the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. That's the CRC preamble. The bill seeks to do almost the opposite respectfully. Hear me out. It loosens the capacity to consent to medical interventions, whose social, physical, emotional, moral, psychological repercussions are poorly understood by children, precisely of their still unfinished neurological development. Let me pause, and I'm speaking as a woman. There are big, hardback women who, after having intimacy with even the right mind, the right man, their entire lives have been impacted. Worse yet, with the wrong one. Some take years to recover. Why do we feel as a society we have no option but to treat with the very real issue, including of the abuse of minors by older persons, by opening the door like in this manner? And what I am saying is, just last year, 2024, there was huge debate in the country. Gun reform, increase of gun violence. You know what the state did? Do you remember what the state did? They increased the penalties. Right now, the penalties for gun violence or gun infractions in Grenada is tantamount to murder and treason. And I'm saying, where is the similar protection for our children? That is all I am asking, In keeping with international obligations that parents have to their children, and the state have to the parents to respect those obligations, and the state have to the child, where is the increased penalties, for instance, to dissuade perpetrators from abusing our girls and women. As an empirical matter, children's brains do not form fully. They don't mature fully before the age of 20 even, impairing their ability to assess risk and engage in moral reasoning. I want to now take this moment to delve a little bit into the language of the bill. The bill says this 16-year-old, and as we noted, potentially 12 at some point, we're going to get to that, can access, and I quote, any, that word there is very important, any sexual reproductive health treatment.
Johanan, I don't want to restrict you, but if you could wind up in 5 minutes, that'll be all right?
Absolutely, certainly.
Okay.
This term is loose. It is without any clear definition in law.
Which term it is?
The term any sexual and reproductive health treatment, I'm dealing with any here. It leaves the door open, and by extension, the nation children's exposed to all and sundry ideological whim and fancy. We just saw what the appropriate education is, and there's worse, about what such sex services involve. In legal drafting, and we know this, the word any is typically interpreted broadly and inclusively, unless otherwise limited by context or expressly defined. Courts and lawyers often read any to mean all of the available kinds or types within the scope of the subject. And so, as my colleague here would attest, reproductive and health services also could include something as sterilization. What if a 16-year-old goes and say, this bill allows her without a Gillick test to make a decision, she's researched sterilization, she wants to be sterilized. I leave it to your imagination. I want to wrap up quickly by looking at the 12 and up and the affirmative resolution that is proposed. Now, we saw the process that this legislative process has unfolded in the media partly because the current constitutional parliament is such that the current administration has the majority vote. And some of us even had to raise our voice a little louder and put on a little act, because it was clear that whatever consultation it was being done to pause, to consult, was just a rubber stamp, because there was every indication, as stated over the state actors over the media, clearly indicated that they were going ahead with this bill. And what is an affirmative resolution? The Honorable Casey here did well in describing what it is, and it's important to be a safeguard and what's not. But what I want to invite into consideration is that the current constitutional parliament, under the current constitution, an affirmative resolution is just a rubber stamp. I am saying, just imagine with a bill with such wide-reaching implications dealt with in such a manner. It's like, we're still going ahead. Notwithstanding what you say, we're still going ahead. An affirmative resolution, you think that it will get any big set of debate and hold back? I beg to differ, because Grenada has signed over on the altar of the Samoa Agreement, and there's billions of euros to be had. So I want to say, at the end of the day, what we Grenadians, we mothers, we fathers are very well aware of, there is an issue. There are some suggestions made. The good Casey made a suggestion in his paper before he demitted the office of the consultant in Spotlight Initiative. He talked about the Romeo clauses, similar to what Trinidad have, for young persons who are having sex with each other, and perhaps maybe 2 to 3 years, like within 15, 17, the age group. And the Romeo clauses will prevent prosecution to anyone within that age group. That's a good suggestion as a start. There are so many other, the 10-year-old, the 3-year-old, the 8-year-old that is not addressed in this bill. Nothing stops the states from coming in and safeguarding those children. The 16-year-old that gets pregnant, nothing in the law in Grenada, there is no doctor, no medical ward, no hospital in Grenada that will turn away a 16-year-old that comes and says she's having some issue with her privates, or she has an STI, or she wants to get tested. Tell me which doctor in their right mind will turn away a child in need, a child that is pregnant. So I believe
So,
that I have sufficiently touched on the main areas of concern. And I want to end with saying that we must not, as a society, underestimate the power of parental guidance. The rights and responsibilities of parents are important. It must be guided and guarded. There is no state that is so great, no ideology from outside forces that is so yummy that it warrants a bill clearly striking out in every case, no consent necessary. That is not the way for us to go. We will not stand for that. I believe that parental beliefs must be respected. This issue we are taking up is not because we want to make noise. It matters to us that the state recognizes the rights and responsibility of parents as encapsulated in the CRC. States must respect the rights of parents to direct the education of their children, especially in sexual matters and decisions regarding their reproductive and sexual health. And I call on every PTA in Grenada, the parents on the PTA, ask the schools, show me what you guys are teaching my children in this comprehensive education, this euphemism, these sugar-coated terms, because we, the parents in Grenada, also know that the state of Grenada has signed on to protecting our rights and recognizing our rights. Thank you very much.
okay, thank you. Okay. At this time, I just want to recognize those sponsoring the program once again. GEL Professional Solutions Inc., GEM FM carried this program on FM out of Canada, and Grenada Technical and Allied Workers Union, Zita.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, so at this time now, basically we will have a general discussion among all the participants here. We'll also take some of the comments and the questions from the chat and have any of the participants answer or comment on those comments. Yeah, I don't know. Casey, I see you have something to say.
Yes, thank you very much. I'm grateful to my colleagues for giving their thoughts on this program. The discussion continues to be an important one. I have noted the DPP's concerns. I have noted his position. He is the highest ranking prosecution officer in Grenada. He has been in that position for a very long time. He understands sexual offenses like no one in Grenada understands it from that criminal perspective. I have noted the statistics given by Ms. McQueen. I'm trying to follow what my colleague, Ms. Lafeuillee, is saying. I will leave out my commentary on the international signatures on documents and address it from a legal perspective. I think our viewers deserve that. First, I will say that it is very surprising to hear a legal mind person say that an affirmative resolution of Parliament means nothing. An affirmative resolution of Parliament requires the Houses of Parliament to vote. The Houses of Parliament don't vote on anything unless there is a debate. And the Houses of Parliament, I would think, to disregard our Parliament entirely like that, whichever Parliament is sitting there, is an unprecedented thing to hear a lawyer say, that affirmative resolutions mean nothing. That's the first point. So I would urge my colleague to reconsider her understanding of the law of parliamentary affairs in a democracy. Please do. Secondly,
Permit me, if I may, Ewart. Permit me, please, because it is erroneous and incorrect to misquote me. I said, given the current constitution of Parliament, the majority vote is where? With the current administration. I've never disregarded the
Yeah, but
affirmative
Joanna,
resolution.
I think
Perhaps you misunderstood me.
yes,
I
all
think the
of
issue is that's
is
always the case.
Parliament, every parliament in the world, as currently made up, involves a majority. That's what the people have put to rule the country. So you are essentially saying that because you have a majority in Parliament, nothing matters. And that is a rather astounding thing to hear. You are literally dismantling the entire democratic body that governs a country by saying, because you have a majority in Parliament, it means nothing anymore. Every bill is there. Miss Lafeuillee,
So my
please.
question is, respectfully, my question is,
Please,
can I
yes.
have a question.
Joanna, please let them finish and then you will respond.
Just finish the thought that it would be useful that we give regard to those institutions that we have appointed. And the end of the thought is this: we are here, notwithstanding, we're here in this discussion forum. We're raising these issues. You and I have a voice, and we're saying the things that we wish others to hear. Notwithstanding that you do have a majority parliament. They could have taken this bill to Parliament as it is, get their majority and move on, but they didn't do that because they understand the democratic nature of government. You listen to the people. Yes, they give you a majority to go to Parliament, and you can go there and you can pass things. But one would expect that when you have these types of discussion where you're raising your concerns, yes, and as enthusiastically as you are, that sometimes it puts a pause on things. So that's the first point I wish to make. I am finished with that thought. I wanted to go on to three other things in relation.
Let her respond.
Thank you so much. Casey, I appreciate your feedback. And my simple question to you is this. Supposing next month, let's say this bill is passed, and next month the state decides that it's going to Parliament for an affirmative resolution to pass an order regarding 12 to 15-year-olds. Can you please explain? Perhaps, of course, you've been in Parliament and the government longer than any one of us sitting at the table has. I never have. So can you just educate us on what would the numbers look like for majority vote for this order to go forward? I'd appreciate that very much, and I stand to be corrected.
Well, it's straightforward.
Perhaps a good Casey can answer, because honestly, I really want to hear him.
No. Joanna, let's not try to. It's straightforward. These things are passed by majority.
But what is the majority? Who is the majority?
Yes, but
what's the number that is needed?
That's the majority you have now.
But it's also right. So you are correct. You and I are saying the same thing. You and I are saying the same thing. I qualified the basis on which I stated. It just is a rubber stamp, because I'm saying, given the way that this is being pushed,
let me exercise
comfort, in other words. It is
Joanna,
poor comfort.
Joanna, let me exercise moderator's privilege.
Certainly, Ewart. Thank you.
Both made points on that. Maybe I could go on to address the other 3 points I wanted to raise very quickly. The logic of my dear colleague, Ms. Lafeuille's argument is that if they were so concerned about young children, they would put in provisions to govern 3 and 5-year-old and 10-year-old. And look, they haven't done so. So therefore, there is some sort of, and I'm now putting a word to it, there's some sort of ulterior motive to it. That cannot be logical. that cannot be logical that because we didn't cover 3 and 5-year-old, that we shouldn't carry a limit from 12 to 15. It's logistically wrong. And if I may say this, that when you look at the language of the bill, I've heard my colleagues say, this is the second point, I've heard my colleagues say this, that look, all these other Caribbean countries are different to us. And we have a particular culture in Grenada. I know Grenada is a deeply religious and conservative society. This is a very strong country. I know that. Yet we have a problem. The answer cannot be only to increase penalties for criminal laws. The answer, and you read something from the Convention on the Rights of the Child, and you read this, the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth. But your entire discussion is to remove every possibility of medical and health and sexual reproductive care without offering any alternative. Almost every country in the Caribbean have moved on to put the age of 16 as a responsible age of children to give consent for sex and for medical treatment. But yet we want to take a position to call this a Trojan horse because we imagine that there's so much more happening out there that we are going to interfere with children's right and inculcate and indoctrinate them. Now, how do we make that logical leap? Look at the confines of this bill. You've attacked it legal proprietary. You said the last point. You've said that the bill is legally flawed. How is it legally flawed? It's very straight language. It says, if you're 16 and above, a minor, you can consent to medical treatment. Ms. McQueen and I, others, the DPP, have given you reasons why children need to get medical treatment. Are you saying at all that children should not have medical treatment and cannot go on their own to get it? You just said that a child can turn up and which doctor going to turn away them at 16? We want to put the mechanism in place to allow the doctors to give them coverage to do that, to give the system the coverage, not to turn up and somebody sitting there say, well, this one looks good, so I will look after them. That's not how we want to do it. We want to give them legal coverage. You say the order is, I have given you a number of things. One is that when that order is going to be crafted, you and I and others can sit with the administration if we are given this opportunity, and I hope you and I will always be given the opportunity, is that we can sit and we can say, listen, we need access to health care for children. And access to health care for children is often hindered by the fact that the people who are there responsible for caring them are barriers to their health care. If you accept that as a principle, that parents and guardians are sometimes barrier to a child getting health care. And the DPP just said that. He just said what a mother was doing in relation to a child. So it is a fact that we have those situations. Hopefully not a lot, but we do. And every single child is as important as every other person in this world. Why should we not have a mechanism in place that allows that child to be able to access health care in circumstances, and yes, let's work with each other here, in circumstances when the parent and the guardian are barriers and are hindrances to that process? Why not? Let's find a solution. Don't leave it aside. Let's throw it away. Let's find a solution.
I just want to intervene on one thing, Johanan, because you dealt quite a bit with the Samoa agreement. And I mean, that's not the focus of the discussion tonight, but I think in all fairness, viewers should be clear that under our system, the executive enters into treaty agreements. When the executive enters into those agreements, they are not automatically law in our state. In order for whatever is in the Samoa agreement to become law in our state, our parliament has to pass a law to that effect. So I just want to clarify that the fact that
Certainly.
The fact that these things may be in the Samoa Agreement, I have not studied the agreement, so I can't say whether your interpretation of them is, I agree with it, but the point I want to make is that this is not part of our domestic law.
Okay, so I want to note 2 points here, Ewart, if it's okay. I'll take about.
Yes, go ahead.
Right. First, thank you. Before I address the learning QC on the various points that he made, I want to ask you, or perhaps your colleague, Ms. Henry McQueen, are you aware whether the comprehensive sexual education informs Grenada's educational criteria curriculum? Is that, you said that you were not too aware of the Samoa Agreement, Ewart, so perhaps Ms. Henry McQueen may be able to, it's a simple yes, no, on whether the comprehensive sexual education informs or forms part of Grenada's formal educational curricula, age-appropriate curricula.
The Health and Family Life Education Program in Grenada, which has been in place for decades, much longer than the agreement that you're speaking about. The HFLE program does include sexuality education. How well it is delivered, how often it is delivered, it has been a subject of scrutiny. And in fact, there has been recommendation around strengthening it. And that recommendation is, I'm talking about at least 10 years old in terms of better preparing teachers and the school system to teach health and family life education. And so that has been there. This program has been in the classroom, as I said, for decades. And in this way, because it includes, among other things, that's not the only thing. Comprehensive sexuality education is not only one, it's not the only thing in there. The name, it's broad, health and family life education. So one can always examine the curriculum to see the details in there. But when Grenada speaks about age-appropriate sexuality education, we are not talking about the leaps that you have made, and we know that we have not been doing that in Grenada, and therefore we're talking about real issues. However, this bill that is on the table is not speaking about introducing or strengthening or mandating comprehensive sexuality education and so on. I mentioned age-appropriate education and services as part of the overarching principles that guide how one gets to determining what age for, say, age 16 or age 12 to 15.
Thank you so much.
So this bill is not speaking about the education program right now.
Okay, certainly. Thank you so much. Now, the reason why I asked the question, Ewart, because you noted you weren't too clear on what the Samoa Agreement noted, because Mrs. Henry McQueen did in fact outline that Grenada has to be brought into alignment with these international. I want to find the very important. I want to find the right words. Right. You get it. That encapsulates. No problem.
We can have a program on that at some time.
Certainly. So I want to
really wanted us to focus on the bill.
The learning.
I want to raise something as
I understand. The Learning King Council.
Ms. Lafeuillee also spoke about the Convention on the Rights of the Child and is speaking about aligning with that convention. Grenada is a signatory to the Convention on the Rights of the Child because that convention is one of the core human rights principles, which Grenada signed on to quite a long time ago, like early 1990s, right? And so it is not about, when we talk about alignment with human rights conventions and international standards, we have to think broadly, but at the same time, we have to be in some ways, be very specific. They do not, like the Convention on the Rights of the Child, is critical. The Convention on the Elimination of All Forms of Discrimination Against Women, that's critical. Human rights, the Human Rights Foundation, for example, the Human Rights Charter, these are all critical core human rights instruments. Several other agreements, and we have to differentiate between them and some other agreements.
I want us to stay
I
on
would like
but
to.
I am
I want
just
us to
pointing
stay on the
out to you
bill.
that even in your speaking about and agreeing with the Convention on the Rights of the Child, it is in fact an international standard.
Thank you
Yes.
so much. Ewart, I believe that the reason why it was important to address the policy behind the law, because policy is the ghost behind the law. It informs the life of it. And so I want to address the Learned King's Council indication that I put forward that the bill was logically flawed or legally flawed, but I didn't present alternatives. And
before you go on that, Johanan, I just want, for the sake of balance, I want to make another point. Because you reference the UN Convention on the Rights of the Child and you refer to Article 5, which in fact deals with parental rights, that is so. But as you know, and I guess all the participants know, and many members of the audience know, these conventions and many times laws, there will be conflicting interests. So many times you will see a tension between different provisions. In the same way, I want to highlight Article 12 of the convention. Well, in fact, let's look at Article 3 first, which says that, very short, in all actions concerning children, whether undertaken by public or private, social welfare institution, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be the primary consideration. And then I want to move to Article 12, which says that state parties shall assure to the child who is capable of forming his or own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. For this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child either directly or through a representative or appropriate body in a manner consistent with procedural or national law. So I just want to make the point that if one reads that provision by itself, you recognize, and I guess I hope you agree with me, that the convention, it has both provisions, Article 5, Article 12, and several other provisions, which in some cases it's weighted in the parent's direction, in other cases it's weighted in the direction of the child, and recognizing that a child is an evolving being.
Thank you so much. Ewart, is it possible for me to please address the points made by the Learned QC?
You can go ahead.
Thank you so much. I admit that the ethical and legal tensions in consent. That is clear. That is clear. And in the interest of the child and the best interest of the child, the question begs whether assuming full SRHR responsibility at age 16 assumes that adolescents can make permanent, life-changing decisions without fully developed capacity for informed consent. This raises ethical concerns, especially where counseling and legal protections are lacking. Now, we noted the importance of having that safeguard around the child. We noted that safeguard is important for several reasons. And I want to know, what is the statistic in Grenada that is so grave? Which number of parents, what percentage is so delinquent and so exposing the child and so disrupting the court process as to require that a bill of this magnitude be brought to the table? One, notwithstanding any other law to the contrary. Two, accessing to any sexual service. Is it that, one, Grenada is so debased? Is it that the parents are so delinquent that this general sweeping bill is on the table? I honestly, sincerely beg to differ. I have some recommendations. In line with the Learned Casey's recommendations under the Spotlight Initiative before he demitted that office of consultant, he noted that Romeo provisions could be introduced in the criminal law to allow for the non-prosecution of closing age persons who are sexually active. And then I also noted concerning the big man and them that interfere with those little children, just as how we have stiffer gun penalties, where are the stiffer legislations for that? So my recommendations are clear. Maintain age.
Okay, so Johanan, just to get
My
it, just to be clear,
recommendations,
I
I
don't want to
have
interrupt
4
you.
recommendations because
Yeah, but no,
council
I
said he
just want to
didn't
be
hear my
clear.
recommendations.
I just want to be clear. You are proposing additional legislation. You are not
I am
critiquing this.
proposing,
You're not critiquing.
in line with what Casey proposed as his policy position, the brief that we all have a
Yeah.
copy of. He says Romeo provisions similar to what Trinidad has. I'm not
And
sure he heard me
explain.
earlier. Romeo
Yes.
provisions where young persons close in age, under the age of consent, are having sex with each other 2 to 3 years apart, right?
All
That
I'm
you
saying,
have
Johanan, that
these
is what.
Romeo provisions.
Mhm.
Right?
All I'm
That's one.
saying,
And
as I
two, for
understand,
the older adults who are abusing the younger children, I am proposing, just as how we increased the stiff gun penalties, where are the stiff penalties for
yes, but
persons?
Johanan,
Just as the
I
case he
want us to. All I'm
recommended in
asking
his
you,
policy
please.
position.
All I'm asking
Remember,
you, please.
Ewart, the
Hold on,
bill
hold on,
never
hold on,
formed
hold on.
part of the Spotlight Initiative.
Let me exercise moderator privilege.
Certainly.
All I'm asking you is for us to stay on focus with this bill. What you say may be perfectly acceptable. Many will agree with you. In fact, you point out that the Casey proposed it. But all I'm saying, that is outside of this bill that we are discussing now. Because I have a question. I've heard it said, and you have said so several times tonight. I think I've seen it in the chat also. Where in that bill that is there now, that the right to a parent is removed?
Where the right is removed. I
I
want
haven't
us
seen it.
to turn to thought. Yes.
Mhm.
Yeah.
It says what?
3(4)(a). I'm going to start with 1.
Yes, I read it.
Notwithstanding any other law to the contrary, a minor who has attained the age of 16 years shall have the legal capacity to consent to any sexual reproductive health treatment, including diagnostic procedures, and his or her consent shall be as effective as if that minor were full age. 2, notwithstanding the same language, and the minister may, in consultation, the wording and order published. Now, I want us to turn to section 5, where that minor has, by virtue of subsection 1 or by an order made pursuant to subsection 2, given an effective consent to any sexual or reproductive health treatment, it shall not be necessary to obtain any consent for such treatment from his or her parent or guardian. That sexual and reproductive health is so wide in language. It includes sterilization. It could potentially include abortion because of the loose language of the bill, notwithstanding any other law. What does that do? Cancel out any other law. If a child age 16 goes to get an abortion, she gets the abortion under this bill. Do not be deceived. This law is
Johanan,
very loose. It is general,
Johanan,
and that's it. It is very loose and very general. I will not be gaslit. I will not be gaslit. The law is
abortion is
general.
unlawful in
It
Grenada. You know
needs to
that.
be redrafted or come back from scratch.
But what I'm saying, you know that abortion is unlawful in Grenada.
Yes,
May
but
I?
it says notwithstanding any other legislation that any sexual such service is accessible by that child. So amend the bill and come and say what you want to say.
Yes.
May I?
Amend the bill and come clean.
May I, Mr.
It seems like I am the only one on this panel that is trying to articulate the Grenadian concerns, and I'm going to articulate it with
No,
all
no, no, no,
might
no,
and
no.
force.
That's an unfair comment. That's a very unfair comment.
Well, I want to be clear on the feedback that has been coming to me.
That's a
We
very,
have talked through this bill. We are sitting here. Yes, we are legal minds. I take issue with the good QC questioning my legal capacity. We Grenadians see through this bill, and we asking for a comprehensive bill to come forward that is clear and that is honest and transparent.
So,
May I, Mr.
Can
Layne?
I, just before
May I?
Yes, go ahead.
Mr. Ramdani, can I
yes.
just say two quick things? One is that in 2012, there were amendments to the criminal code, which increased penalties for sexual offenses, including, for example, rape and the sexual abuse of a minor under the age of 13. They were increased to 30 years imprisonment as the maximum penalty. Of course, a judge determines the exact penalty on a case-by-case basis. I also want to remind us of something that, and maybe Mr. Ramdani would confirm. The Gillick test, based on the record, does not speak to 16 to 17-year-olds. It speaks to people under 16. So that Gillick competency test is about persons under the age of 16. And there has been evidence, even for students of the program, or for adolescent mothers who are themselves mothers, where parental consent has been required by medical professionals, and that is one of the other loopholes or gaps in, I should use the word gaps here in the system, that this law is trying to equalize access to all who need it. And by speaking and saying about all who need it, it is not only about persons who are abused, because there are children from very healthy households, but they are not comfortable speaking, or they don't want to speak with their parents or guardians about sexuality, their own sexuality, and so on. And they need the support, they need the care and services. But I would also like us to refer to subsection 7 of the same law, of the same bill, and ask, and I would just point it out and ask Mr. Ramdani as he goes into his remarks in a minute, if you can explain for me if what I am reading is correct, and that there are limits on the sexual and reproductive health treatment for the purposes of this section, because there is a clear list of what it includes, and things like the leap into sexual, sex change and hormonal treatments, and so is not in there. Mr. Ramdani, is that correct, that these are not included because the bill defines the list of services that are available, that should be available in section 7?
That is incorrect.
Let me address that by starting to say that I have not at all. I hope my colleague Ms. Lafeuillee hear me clearly. I have not at all challenged your legal competence. I disagree.
Yes, you have. Respectfully, you have.
I disagreed with your legal views, and I'm saying that your legal views are wrong.
No, they're not.
So I will go on. We can respectfully differ on that. I will go on to say that you asked about statistics. First, I'll address that. The statistics have been stated by Ms. McQueen, Henry McQueen earlier, and Mr. Nelson also gave you the stats. Do you want half the nation children to get into trouble before we can start thinking about this for stats? We have already had.
Do you want to open the door to all the nation's children to less seriousness and fornication, and then raise the age of marriage to 18?
Please,
It doesn't make sense.
Perhaps I can suggest to you that the word consent is not equivalent to demand and get. So when a child walks into a hospital and is capable of consent, it is quite a different thing. And here's a legal interpretation now. Here is a legal interpretation. Consent is quite a different thing from demanding and getting. So when you say people can go and demand an abortion or a sex change, I would suggest to you.
I never said they could demand a sex change. You misquoted me.
Well,
Honorable Casey, I did not say that.
Consent, that they can go in and the doctors can do all of that for them. What are you saying? And here again, we disagree.
Casey, I never talked about going in and demanding a sex change. It is incorrect to misquote me.
That relates to their medical and sexual
I
health.
talked about abortion. I talked about sterilization.
Johanan, you will get your time to reply.
Yes. Abortions are illegal unless there's a danger and the mother of the child is likely to die, and then doctors can perform them. And I've spoken to a medical profession just today in Grenada about this, and they are significant. There are cases in Grenada every other month, every month, where doctors are required and compelled and feel it necessary to save a mother's life. And the doctor did say to me as well that among those persons are minors. Now, we have, if you have one child that is in need of saving, of some law that can protect them, is it a matter of numbers for anybody in this country to say, well, listen, we don't have enough? Everybody can access it, but is a law saying that because the law is there, all of you must come and access it, that people will just pick up suddenly one day and run to the hospital? No, that's not what laws do. Laws cater for situations. Laws are there and is designed to solve issues relating to particular individuals in society. And this legislation is really backed by a need in society. Other countries, you're saying Grenada shouldn't go off on this. It's not Grenada, it's the entire world.
Casey, an exception is not a rule. Learn it, Casey, an exception is not a basis for rule. This is improper jurisprudence. Learn it, Casey, this is not about the other Caribbean countries. This is about EU foreign ideologies coming to rape our law books. And I stand by my statement. I stand by my legal analysis of issues for us.
I agree, you can stand by it.
It's not just about the Caribbean. The whole Caribbean is being forced to accept these foreign ideologies.
The criminal laws of the country.
I have done my research and I stand on my facts.
Affects the criminals and the victims. The laws are not there to criminalize the entire Grenada. So the exceptions are the criminals, and they are addressed by criminal laws. Oh, I think we have lost Miss Lafeuillee.
Yes, we lost.
I hope it wasn't anything that I said.
Casey, what I want to do now, because actually we're approaching 9, but we'll go on a little longer if you agree.
Yes.
Because I want to ask Zita to
have somebody check
on some of the comments and the questions.
Yes. Thank you.
If we could address those, so we could just get the general sentiment.
Yes.
Sorry, I'm actually trying to. Yes, well, one of the questions really that I have, I'll hold it, was for her, specifically dealing with the age of 16 and age of consent. Hold a second, sorry. All my devices seem not to.
As Ms. Barnwell looks at that, I want to say something and make it very clear, Mr. Layne, that the language of the legislation is not in doubt at all. It's pretty clear. What is in debate here, as I understand it, is the policy of the legislation, whether we need to go this far, whether we are at that place. And I hope that at least our viewers would have had the information that says, you know what, the world is recognizing that children are in need of protection.
Sorry, I got bumped off. Apologies.
Yes, there's Ms. Lafeuillee. And you were in the middle of saying something, Ms. Lafeuillee, so I'll pause and let you speak.
Learning Casey, I know this is a heated debate first, but I love you. You know I love you. Okay? You know I love you.
I know you love
Okay, this is a heated debate for all of us. And what I am saying, before I got bumped off, what I was saying is that the idea that this is Caribbean, let's look at what our brothers, Jamaica, for example, their position and whatever. I am saying, from a policy perspective, from even an ideological perspective, the language in the bill is not legally sound. This thing about any sexual and reproductive health treatment leaves the door open to changing. It's not, the frameworks are not there within the legislation.
And do you think that should be tighter?
Yes, it should be tighter. The concerns are real.
I had a question for Casey in terms of regulations. If this amendment should not provide for the making of regulations, because she is saying, and I can understand that view, that terminology, and I've heard that from many people, that maybe it is too wide. And
I
maybe
will say this,
regulate.
yes, I'll say this, Mr. Layne, that we compared the legislation in other jurisdictions to the one that is being proposed. And in other jurisdictions, the 16-year-old and above minor can access any form of health care, well, can consent, let me use that clear word, can consent to any form of health care. In Grenada, the proposal so far, and the proposal is not any form of health care or health services, it relates to sexual and reproductive health.
Reproductive. Yeah.
And these terms are, I do believe, but I suppose this is something that the drafters can look at again. The bar can contribute perhaps in a draft they would like to
And that
see.
is supposed to be conjunctive.
Yes,
Not so?
yes, sexual and reproductive health means something in the vernacular. It means something in the legal language, and we say it's not at large. But if, for the sake of moving this process forward, the bar it could be invited to craft language that limits it to the kind of sexual and reproductive health issues that they would like to see covered. And surely I believe that would be given due consideration, and seeing the enthusiasm of the bar on this issue.
And I
That,
appreciate that. I
yeah,
truly appreciate that considered position,
yeah.
Casey, and I respect you for that. And because it is especially important when that language is cleared with the phrase "notwithstanding any other law to the contrary." That gives this clause supremacy over every existing conflicting law. So I really appreciate and respect that you can stand and look and say, perhaps, we can tighten that language a bit, and it's not fanciful to recommend that.
I also want to add that they had looked at this in particular, and perhaps if a definition is given as to sexual and reproductive health, maybe that's another consideration. I know Ms. Redhead is actually listening to us as we speak. We can, this can be the discussion, I think, and perhaps get a sort of a consensus position from the bar whether the language as is presently used really means what it says, or it needs the addition. So thank you, Ms. Lafeuillee. It's a
Certainly.
useful
And just
process.
while we're talking about the language, remembering as well that under Section 7, for the purposes of that section, sexual and reproductive treatment is defined, but it's
Includes.
illustrative. It's illustrative. It's inclusive. It's not exhaustive. And so
Yes, it
again,
includes.
that
That's
loose
what I mean.
languaging gives parents' hearts a little palpitation. It gives parents palpitation because they are also concerned, as panelist Henry McQueen noted, that children are already dealing with anxiety and depression. One of the things that could get you into the fastest anxiety and depression is sex with the wrong person and even the right person.
Ms.
And so,
Lafeuillee,
yes,
Okay.
am I hearing you saying that you're getting closer to saying that we can do this? We can
I
do
am
this.
getting closer to saying, yes, we can do this with transparency, straightforward language, and we can do this with that. We need that context. Don't give us heart palpitation by making us believe this still gunning down to Parliament and affirmative resolution right now. That's a core comfort but based on what you're saying now, I believe that we can sit at the table and get something straightforward dealing with the issues that are addressed. The sort of Form 5
I
get being sexually active, and then the older man and them interfering with those young people, right?
I
Let's
want,
deal with the issue straight on head.
yes, I must add to that
Sure.
this conversation is actually us being at the table. This is why we're having this conversation, not me sitting here tonight saying this for the first time, that Ramdani is now saying that. I am not now saying that. The fact that your administration has pulled this bill from Parliament, maybe you didn't go the way you want, and you've gotten it here. This discussion that is happening in the Bar Association chat that I'm seeing, that is happening in our news media that I'm seeing, all of that is where we are. We are in that conversational mode, Ms. Lafeuillee, and I'm
And
so
to be
grateful.
fair to you, I
You-
agree. To be fair to you, and I quote you in your letter, 21st February 2022. You said, and I recommend you for I commend you for this. You said here, I write to you on this component of the Spotlight Initiative, and
And
you
that's a
said,
letter to the AG, right?
may I kindly request, yes, the Learning QC wrote this, may I kindly request that this note be shared with the persons who will join the consultations to be arranged. Please also share the various position papers and indicate that I am prepared to discuss. Please note that I'm traveling, and Sonia gave notes. So you really invited, the first paragraph you said, with requests that consultations be arranged with faith-based and other relevant organizations in the upcoming weeks. So I must attest, KC, that has always been your position. The collaborative has always been your position, and so I can attest to that.
Yeah. So
Ewart,
at this point, I just want Zita to deal with the comments and questions and so on.
Right. So I do have one question for Joanna. The question is, I guess, Joanne, sorry, the clarification I think one is seeking here has to do with when we say children, if we are distinguishing between those who are 16 and below 16. Here's the question.
Wait, perhaps your accent, but I'm not hearing you clearly. If you can just maybe slow down a little. Yes.
Okay. So the question is, the age of sexual consent in Grenada is already 16. If a 16-year-old can legally consent to sexual activity, why should it not also be allowed to consent to sexual and reproductive health treatment?
Certainly. Thank you for the question. Very pointed and very good question. I believe I dealt with an aspect of it within my discussion. I talked about the loose language of the bill. I talked about the policy informing, the foreign elements informing the structure and the spirit of the bill. And so I was voicing the concerns of many parents who are saying, even if my child is 16, I cannot fathom that there is a bill that is telling them basically, go to your surrogate family, the state, leave me out. It encourages secrecy. It encourages the breakdown of familial relations even. And the other concern is, what about when that 16-year-old goes, say, for example, to have an abortion, just using an example, and something happens to her on the surgical table? Now, will the state and the surrogate state come by the bedside and nurse her back to life? So then that takes 6 months, a year, depending on how serious it is. What if a child dies on the table? Who is going to take responsibility? Mind you, this act further absolves, it absolves any person from the civil or criminal liability. That's Section 6, solely by reason of having administered sexual or reproductive health treatment to a minor with his or her effective consent in accordance with this section. Ms. Henry McQueen noted that don't leak so far that right now we're not talking about sex change and so, but what about when we get there? There's a bill for that. What about when the surgery go wrong? The access, it includes surgical and services. We have to be honest with the people and ourselves. And let's look at this, and I agree with the good Casey. I'm happy to be here at the table to address these concerns, to raise these concerns. So no, it's not fanciful. And so we ought to address it with clear language, specific outcomes, and to really deal with even the 0 to 10-year-olds that are being abused, because nothing in the act is dealing with them. To 11-year-olds.
That would be a separate act, Johanan.
Well,
that's a separate legislation.
Okay.
Hardly find a
if Zita, if you can take the comments.
Did I answer your question?
Yeah.
Thank you.
Well, I believe so. I think the question really has to do with, as I've said before, and you have tried,
if you can take
extensively.
So what, in other words, what I'm saying is the
sexual consent is 16.
Not the Gillick principle. The Gillick test can only be administered by a medical professional. No states. I understand the argument, but the Gillick test is not just age specific. And the Gillick test dealt with a 16-year-old that was looking for an IUD. It was a 16-year-old.
We have some communication issues.
So what I'm saying is that,
can you hear me?
Johanan,
yes.
Zita,
Are you hearing me?
If you can go to the chat, please.
Go out.
No, Zita, to go into the chat, as we discussed.
You want me to go into the chat?
No, Zita, that's just to read some of the comments and.
Okay. You want me to read the comments or Zita to read the comments?
I want Zita to do it, but like she will lose her.
We lost her, I think. She's frozen.
Yes, she's frozen.
Okay.
So just to finish up what I'm saying, there are 16-year-old parents with 16-year-olds who wants that the Gillick test and the competency of the child. You have some mature 16-year-olds and you have some very docile, sheltered 16-year-olds. And there are parents that are saying, even with my 16-year-old, I am not comfortable with the state kicking me out. I am not comfortable with the state saying explicitly without my consent.
Johanan, I just wanted to deal with that point there because I said earlier that I don't think you satisfied me by showing me where the law takes away the rights of a parent to be involved.
But did you look at the section that I referred to?
I did, but I will tell you what is my take on it.
Yes.
Right.
You mean the shall not be necessary phrasing. In other words, a child can obtain the consent if he or she wants, but it is not necessary. So you're trying to, it's a bit pedantic. I get your point from a legal perspective. I see your view, but on the face of it, given the reading of this bill, and quote unquote the education that will roll out in the schools by teachers who are not legal lawyers, when any child read this bill, I don't have to tell my parents nothing, and let me go and get what I need, right? And I'm not saying that is bad in all cases. I am saying the law should also have frameworks like reporting standards. The Gillick test, for example, could be legislated as the good KC recommended in his positions. So, so it's intriguing with the 16-year-old. That is my take on it.
Right, good. So let me just, and what I'm saying here now is not original. In fact, I'm taking something that I heard from the bishop, the Catholic bishop, in a different program. And his position was, you have to look at this thing from three ways, from at least three perspectives. The biblical point of view, which is basically the equivalent of what you were referring to as a natural law, Johanan. Our customs and practices as a society and a community. Our traditions, that was his terms, his term. And then, finally, and we cannot ignore the reality. And I think in different ways, you alluded to that. Part of the reality that we have is that there is a significant percentage of minors, as you say, mostly they form 3s, 4s, and 5s, those between the age of 15 and 17, who are sexually active. 1, and 2, who would not go and disclose that to their parents. Yeah? Who may want to, and maybe it is in their best interest to access certain medical and reproductive services that may be in their best interest, but they would never want to go to their parents. That's a reality that we face in the society. And how I read the law, it is seeking to address that, among other things. Among other things will be like cases where the parent or somebody who is in a position of responsibility is abusing the child. But fundamentally, as I understand the law, it is not about taking away the right of a parent to know, but it addresses the circumstances and the situation, which is real, where minors are into sexual activity. It is in their best interest to receive advice, counseling, contraceptives, whatever it is, in their best interest, but they will never go to their parents. And in those situations, you have a legal framework that allows for it to be done in an organized way. I am fully on board with you that for example, the Gillick test should apply, and there should be regulations. Reported that there should be regulations, for example, which have forms. So it is not just as Casey said, a child come to you and say, I want this, I want that. But it should be a process. And part of the process, as you know, with the Gillick test, is that the medical person should seek to persuade the child to involve their parents. And it is only if they are unsuccessful in doing that, and it is their assessment that it is in the best interest of the child to get that service, then they should proceed. But I am bored with you, and I agree that the legislation should be tightened. I thought about probably necessity for regulations so that we could have a tighter system that addresses and achieves the objective, that fills the gap without creating all this other set of drama, which apparently is involved. Zita, can you go to the chat now? I will try to finish up in 10 minutes, if possible. You are muted.
Yes, so sorry. I'll try and get a few comments in because I got knocked out. So one of the comments says, the children at risk who are on the street, who have been assaulted, who are being abused, who are not yet 18 must know that they can approach a doctor and get help when family will not. That's a comment. And someone else says, consent has three parts: risk, benefits, and alternatives. The majority is not necessarily right. The minority is generally most times correct. And someone asked to Joanne, don't you think this bill could encourage children who are being exploited by their parents to come forward? That was a question to Joanne. And someone says, the law is for the lawless and to protect those who suffer from same. Children who can speak to their parents would not normally speak to them on such issues. Those who have good relationships will. And someone says the solution is to hold the particular parents accountable and not punish responsible parents who don't abuse their children. The law will encourage all children to defy parental rules in the home.
Ms. Barnwell, may I be allowed to jump in on one comment I've seen?
Of course.
Thank you. I saw Mr. Titus, Raul Titus. I'm thinking it might be the same Mr. Raul Titus I know. He said that the Gillick test, as he knows, it has not been implemented in any of the Caribbean countries. I wanted to point out to him that Guyana has passed regulations implementing the Gillick test in 2008, the National Sexual and Reproductive Health Policy. And so it's in place for medical practitioners in Guyana since 2008. And of course,
in relation to which category?
In relation to the Gillick test, in relation to, let me see if I can find the actual regulation. Yes. But in the meantime, Jerry Edwin is also saying, my colleague at the bar, the criminal bar, that he says the problem, he notes the observation of the DPP, and the problem is worse than we know. And he practices at the criminal bar and does a lot of sexual offense trials, as I know.
One of the things that I want to note is that we also, in considering or reconsidering the position, a national position, we also have to take into consideration how that very instrument that's supposed to protect could potentially be used as an instrument of abuse. So I'm going back to what the conclusion drawn here between ourselves, that there definitely is need for returning to the drawing board and tightening some things and really saying what it is we want to say. Yes, so that it does reflect good jurisprudence, which is laws created for the society in the specific society, rather than, the other way around. Thank you.
Yeah, Zita, if you could just, any others you just want to?
I think in terms of because I think what happened as usual, people were making comments as you were speaking, so some of it might seem out of context as they were responding directly to some things.
It's all on the side. It's all here, on the side of the chat here.
Yes, right. So I went up. So I'm just simply saying some. Yeah.
And of course, the comments are very passionate.
Yes.
One person is saying, if I may just, because one person has the view, I think it's Dennis Clark, He said, and that's clearly a policy position, and that no child, let me see, I missed it. Basically, he said no doctor should be permitted to examine a child, a minor, in the absence of a parent. And that's clearly a policy position, and I don't think that even Johanan, and I say even to tease you, even Johanan will agree with that.
Well, let me say this, right? What the truth is, with all the proper safeguards in place, in every profession you have abusers, huh? Medical profession, legal profession, politician, you name it. So, to some extent, I do agree there needs to be a safeguard. In other words, even if, listen, right? Even if it was a situation where a child doesn't feel quote unquote safe to let a parent know that they're going for this treatment or whatever, they're going to get examined or whatever. Why not have school nurses across the board in Grenada? I think that school nurses are needed in schools. Because rather than a child going to a quote-unquote medical professional, in some sterilized office, go to the school nurse guidance. Counselors could even be told. So station a school nurse, whether it's in each parish or so the bigger school, station a school nurse. Station a school nurse so that at least there is a little buffer. The social nets that exist in a society are important for a reason. They're there, they exist for a reason. So we don't need to jump from the parents just straight to a sterilized medical doctor. Even as a big woman, and many the women here may feel the same way. Even when we go to get our prenatal or postnatal checkups and so it's a little, intimate for a doctor to be, in you like that. And so what we are saying in the light of the child's safety and the best interest of the child, and even in respect to the parents, we have to have things tightened up. This legislation has to be tighter and read more direct and smoothly and give the proper frameworks and whatever needed to make sure the child is protected. So my answer to you, Ewart, it depends. It depends.
Right, good. Our lawyer's answer. Okay, good.
I do have one question. I just have one question. I have one concern or question. And this has to do with whether it's any medical, surgical, or if it is a diagnostic treatment. And whether there is room in terms of the provision of the advice for non-conventional matters, non-conventional. So for instance, there has been some research recently speaking about the side effects or long-term effects of taking certain type of reproductive health treatment, whether it is the pill or whether it has to do with, there was one recently called Mirena. Would this bill, in terms of its treatment, therefore means that any doctor who decides to use non-conventional advice, would that be also acceptable? So I know most doctors are trained in the system for the conventional medical practice. Would it leave room for non-conventional
When you say
advice?
non-conventional, what do you mean by non-conventional?
So for instance, it speaks broadly to sexual reproductive health and treatment. Let's say a child as early as 16 found out that she has fibroid, and some of it has to do with going to undergo a surgical operation, while you may have naturopaths simply saying that this can also be controlled by diet, this can be controlled by taking things that are herbal. Would that also be acceptable? Because it's non-invasive.
Based on your question, I actually see it as being a basis for even more reason why a parent should be involved in making such a decision. Because remember, some treatment for fibroids could also be removing your womb. And when a child turns 20 or 25, they could utterly regret that decision. And so going back to the CRC, a parent guides, the responsibility is helping to guide a child, right? Based on the increasing capacity. So yes, I believe that's a sort of basis. So being softer, this explicit language about, not necessarily with the consent, or so to speak. I believe that there is room for the legislation to do so. Tighten it up a little, and let it be
Okay.
more reflective of our
So
society as we
because
are.
thank
Exceptions, we
you.
deal with the exceptions, and
Yes.
yes.
Thank you, Johanan. We have to come to an end now. So I just want to, before I invite final comments, I just want to thank the sponsors of the program once again: Jail Professional Solutions, JMFM, Zita, and we will move directly to final comments. I will start with Elaine.
All right, thank you. I am very pleased to be part of this program, and I hope that all our discussions would have has shed some light on the actual contents of the bill, and even advised us or opened the door for us to look at ways in which strengthening can take place and so on. I want to indicate here that I am also pleased that Ms. Lafeuillee, as well as some of the people who've responded in the chat, recognize that basically aligned with what the Minister of Legal Affairs and Attorney General said recently, and that is that the government is willing to look at changes to strengthen the bill, to adjust the bill before it goes back to Parliament. So that is a very good space to be at. Just want to mention as well that access to information and services, when adolescents have access to information and services, this research has shown that it does not cause children to become secretive or disobey parents and so on. But in fact, it allows them to even see the need for encouraging or speaking with their parents. And parents also see more need for speaking with the children, so that it does not encourage secrecy. It does not encourage that parents be replaced, but that these are in fact, it's expected to support children as they mature and grow into adulthood, when they will be making all the decisions for themselves by and large. So in closing, I want to say that this bill has caused Grenada to be in a place that we needed to be a very, very long time ago. And that is open conversation and the space around sexuality and talking about sexual health, talking about sexual education and services. We had not been in that place, and we needed to be there for a long time. So I am hoping that in very short order, we can see some conclusion to this conversation, that the bill, if it needs to be tightened, as mentioned tonight, that it's done, and that the government has, as indicated, can be advised on what should be the next steps. So I'm really looking forward to that, and I thank all of you for your interventions, and say pleasant good night to all of us.
Okay, thank you. Somebody has, I think, two systems on, and let us lead in their feedback. So I don't know if we could just correct that while we close. Johanan, your final comments?
Certainly. I will end by reminding that Grenada took an oath of allegiance change recently, and we now pledge our allegiance to Grenada and by extension Grenadians. And I would also hope that our constitutional preamble is considered in the whole context of the matter, recognizing the supremacy of God. And in closing, I would say that I am happy to note that at least the very real concerns seem to have been heard And it appears that there is some consensus that there needs to be some meeting at the drawing board again. And I'm grateful, Ewart, that this discussion happened. I think it was a very fruitful discussion. Um, and I will end by quoting Lord Atkin in Donahue and Stevenson. When the law was based on Christianity, he said, the rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would likely to injure your neighbor. Who, then, in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my acts that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. Thank you all for your kind attention.
Casey?
I want to begin where Ms. Lafeuillee left off and say this. The law of duty of care owed to your neighbor is one of the greatest and widest area of the law, negligence, because many people don't have regard for their neighbor and they breach the duty of care. And so we are here today hoping to have a duty of care for our children. That's why we're here. And we are putting rules in place to carry out that duty of care. I have looked at the comments and I'll tell you this. Those parents who are speaking of values and they're upset, I'm very glad for them, because I know that those are the parents who will be speaking with their children. Those are the parents who will have the values that will instill in their children that they will go and speak to their mother and father about these things. We're catering the law that is being proposed is not a law that doesn't respect values in our society. We must have a value in our society that says we must love our children and we must care for them. That is a value in our society. I would like to believe that that value exists. And so this law, this being proposed, is not addressing the parents who are upset. Yes, we'll be upset. I'm a parent of a daughter that is just about to become teen. And I understand the ramifications, I hope, of this law. And so I do believe that the conversation that is ongoing is a very useful conversation. I believe Ms. Lafeuillee represents a critical voice that is necessary, a voice that makes us think deeply about how we approach this. She's brought to the table, and others have brought to the table, things that we must think about. And hopefully, at the end of these sessions, we're going to get it right, with the end result that our children will have access to health, have access to care, and we'll be a better society for it. We can't continue to look at the newspapers and see harm being caused to our children. We can't continue to have the assizes filled with sexual offenses, and all we are interested in doing is punishing the offenders. We must approach the health of our nation holistically. We must approach the health of our children holistically. We must come at every angle to tackle the ills that we see that exist in our society. And I believe we are in a good space, as Ms. Henry McQueen has said. We are in a good space. Ms. Lafeuillee has said that this is a good conversation. We are getting somewhere. And I do believe that we will get somewhere good for the nation of Grenada. Thank you very much, Mr. Layne, for having me here, Ms. Barnwell. I am so privileged to be part of these conversations, and I am ready again anytime to participate at this level. Thank you very much.
Zita?
Well, I just want to extend thanks to everyone who's been watching, listening, and a special great thank you to the panelists. I think, based on looking at the comments, that this was an exciting and educational, enlightening. Some people have learned quite a bit tonight based on what they're saying, and some people have quite passionately expressed their disagreement with the passage of this bill. But I am Vincentian, and we don't have that issue here as yet to deal with this. So I want to wish all the Grenadian people the best in the passage of this bill. I hope that the kind of tweaking that is necessary is done in consultation with all of the stakeholders of Grenada.
Yes. So I just want to say thank you to the panelists and thank you to all the viewers. And I just want to make the point that based on the fact that Parliament was prorogued, my understanding is that the bill is no longer before the Parliament as such. So I think it's an opportunity, and I suspect based on what I heard the Attorney General say and others say, that the opportunity to revisit and to strengthen the bill will be taken. I want to once again reiterate what I heard from the Catholic Bishop of Grenada when he made the point. It's not just what, there are three things we have to look at: the moral law, you find it in the Bible, our Grenadian traditions and Caribbean traditions in terms of parenting, and we are very strong on that. But we must also, and we cannot hide and bury our heads in the sand to the fact that there is a reality out there of which leads to the conclusion that there is a significant percentage of young people, in particular between the age of 15 and 18, who would not go to their parents before they seek the kind of services that the law provides for. So I don't think, as my reading of the law, it is not about taking away the right of parents to be informed and to have their consent, but it is to fill those gaps. Yes, there are weaknesses in the as presently drafted, and I can understand that. No one is perfect. I think there's a need for regulations, but most of all, it's clear that there is a need to revisit this and for wider consultation. Once again, thank you to everyone who viewed. Thank you, Casey. Thank you, Johanan. Thank you, Layne. And of course, thank you, Zita. And good night.
I love you all. Love you all.
Okay, indeed. Same to you.
Good night,
Okay,
everyone.
bye.